Tisdale. Mr. Tisdale's present, all counsel present, the jury's outside the courtroom. Okay, we got a new and improved, corrected version of the jury instructions.
Yeah, with regard to the verdict form, Mr. Glenn and I discussed it again. He prefers the original verdict form. I'm fine with that, so that issue's off the table. We're going to use the original verdict form we had agreed to yesterday.
Okay. Oh. Okay, Mr. Glenn, that's correct, that you're agreeing with the form of this verdict.
Yes, sir. This is the correct one.
Now, the final package, I just want to confirm the state doesn't have any objection to the final package that was delivered.
No, the one I sent this morning just added that law enforcement language that got deleted when we did our corrections yesterday. So.
And also, I took the liberty of making some, I think, 4 additional copies to pass out to the jury when they retired, deliberated the instructions.
That's fine.
Okay. Yes, sir.
One final matter, I do need to renew my objection to mannequin present in the courtroom. Notice or argument needed to be where already been made.
Does the state wish to make any other comment?
No, I'm done with that issue.
All right, I'll note the defense objection. Assuming the state's going to refer to it during their argument, I'll permit it to remain in the courtroom. Now, the mannequin, as I've advised the jury and we discussed, is not evidence and it will not go back to the jury room. However, the clothing items that were admitted will go back. But I'll note the defense objection to it. Okay. Now, just so you all know, we provided menus to the jurors, and they've already made their orders, I think, and the sheriff's office is going to take care of their lunch thing, just so you all know. That was one of the things we were waiting on. Okay, now, thank you all for bearing with us. Please, politely and respectfully as I can, out of respect for the parties, the lawyers, and certainly the jurors, respectfully ask, as Mr. Ryle said, y'all please turn off any cell phones so they don't accidentally go off during the closing argument. If y'all will please be as quiet as you can so that I'm able to hear the arguments, certainly the jurors hear the arguments. Please also, of course, no gestures, no comments, no signs of approval or disapproval while closing argument is proceeding and while the court's in session here. I think y'all can certainly appreciate why I asked, so please be quiet in here. I don't want any comments or gestures, approval or disapproval gestures in any way, and please be quiet so that the jurors can hear the closing argument. All right, state ready to have them come in?
We are, Judge.
Defense ready to have them come in?
Yes, sir.
Okay. Mr. Backdahl, you'll be speaking for the state?
I will.
Mr. Glenn, you'll be speaking for the defense? Just so I know who to call on. Okay. Now, one other thing. What I anticipate doing once they're instructed is releasing the 3 alternates for now. I'll instruct them if needed to have them come back Monday.
Right. And Monday?
Yes. Isn't that when we were doing it? We were talking.
No. But, I mean, we'll have to address that issue. Remember, we've got it.
Oh, okay. When we were starting Tuesday?
Well, that was an issue that has not yet been resolved. I'm sure I would ask at a minimum that we don't come back till Wednesday. And quite frankly, I'd like more time, but I understand the court wants to try to finish by the 9th, which is when you had indicated we would be done. So.
Okay. Well, we'll talk about it. I just need to tell them when to come back if necessary.
Right.
The
alternates. Call them no matter what. And I would ask that at the conclusion of Mr. Glenn's closing, if you could give the jury a quick break so I could get set up. I've got a couple of changes I need to make in this because of the verdict form issue, and so if I could just have 5 minutes.
Just remind me.
All right, thank you.
Just one other thing, renewing judgment acquittal motion made earlier, no further argument needed. Yes, sir. Renewing judgment acquittal motion made earlier, I'm not going to make any additional argument. I do need to renew them because evidence is closed. And with regard to the scheduling, I personally suggest that we work something out where the alternate call in on Monday.
Okay.
And figure out what the schedule is.
Okay, we'll talk about it. I just didn't want to forget them. The state wish to make any other comment on the judgment of acquittal motion at the close of all evidence?
No, I do not.
All right, I find at the close of all the evidence a sufficient prima facie case has been established to go to the jury. Be up to the jury to decide whether the state's proven its accusations beyond and to the exclusion of every reasonable doubt. Therefore, I'll deny the motion for judgment of acquittal. At the close of all the evidence, I'll note the defense objection. Okay, Mr. Riles, bring me. And if y'all want any time warning, let Miss Leslie or Miss Deborah know. They'll be happy to warn you if you wish to have one.
These are dead, but I can have to move forward to the witness stand so I can hear their own.
Okay, wherever you need to get.
Okay.
I can start till you're ready.
Yeah, the court coming.
Is there electricity back there? Thank you. Are you finished? Do you need anything else?
I don't think so, thank you.
You may be seated.
Thank you all very much. Just bear with us just a minute while she gets her equipment ready. Okay, we're on the record. All counsel present, the defendant's present, the jury is present. Members of the jury, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the opponent has spoken. Give Mr. Backadall your attention, please.
vehicle.
It'll be a red Toyota Corolla.
That's how we got shots fired. Well, skewed. Thank you.
10-4, shots fired, rolling rescue. I need a location.
South 7th Street northbound. That's all. Sergeant. LP, we need help. Sergeant down. Sergeant down. That's an alert. Is the vehicle still there or did it take off? He took off. Last he headed westbound. Westbound Manila. Black male, white shirt, dreads. Looked like he had on blue pants. I fired a couple rounds at it. That's your area of rescue. Facts. You're in a court of law. And all that matters is the facts. So, what do we know? We know that on February 28, 2013, Sergeant Gary Morales, a newly minted sheriff sergeant with the St. Lucie County Sheriff's Office, put on his belt, put on his badge, and stepped out his front door and went to work. And because he was new and because he wanted to make a difference, he had a plan that day. A plan to protect the neighborhood. A neighborhood that is a regular working class neighborhood. This isn't your high-end neighborhood that gets special attention. This is your run-of-the-mill working class neighborhood that's been experiencing some minor problems. Some burglaries, some car burglaries, some thefts, some vandalism. A normal neighborhood. Sergeant Morales went to work February 28th to protect his neighborhood. And he paid for that dedication with his very life. Because two parallel chain of events were set in motion on that day. The other is a chain of events that lead to the murder of Sergeant Gary Morales. You see, what happened is the defendant went out February 28th. There will be dispute in my argument as to why he went out or where he went out, and we'll talk about that. But what we do know is he went out with this. And what you know beyond any doubt, beyond all doubt, is he legally cannot possess this. And yet he went out that day. And something happened. And unfortunately for us, it's something that is lost to history for all time. Because the reason for which he was being stopped on that day is...
Approach, please.
Please wait for me, gentlemen.
I'm going to take a look at this.
Somebody gave me their headset.
You okay? Okay. He left his home February 28, 2013 with this firearm in his possession. And as I indicated to you, something happened. Sergeant Morales pulled him over for some reason. Has he illegally operated a car without a license? And lost to all time, for all time, is why. We'll never know why, because the officer who conducted the traffic stop was murdered at his hands. The evidence established that as Sergeant Morales attempted to pull the defendant over in that window, as you heard on the tape, because that memorializes for all time what happened. The defendant fled. And who runs? Innocent people don't run. Guilty people run. People who have something to hide run. People who are concerned about their future run. And he ran. And he ran for two reasons. He ran because of this and his suspended license. Because he knew Gary would find both. And he would end up in prison. And so to avoid that fate, he took a human life. That's what we're here about. Now, you know, the first day you all started filing in here, I remember it. I'm sure you remember it. You sat right here. One at a time I brought you in, then we brought you all in. And we talked about big, heady issues. You remember that? We talked about racism. And we talked about profiling. And we talked about good cops. And we talked about bad cops. And we all acknowledge there are good and bad in all professions and races. And then what we finally came, and even during the course of the questioning, there was, could there be a situation where a fellow citizen could use force to defend his or her life against a law enforcement officer? And everybody, I got to tell you, it made me a little sick in my stomach. But everybody, yeah, that could happen. And it can happen. If the law...
All right, if y'all will approach, please.
So in the end, the issue as we discussed that, what I said to you folks, what I said to each of you probably individually and then certainly as a panel is, the world spins outside that door. There are events taking place in the world that we know about that affect and influence how we perceive the world, but something great happens here. And when you walk through this bar and you enter this courtroom, the law controls. And now whatever feelings or opinions or emotions or bias or sympathies or prejudice you might have out there, you leave out there and you judge this case on the facts. And so now all the hypotheticals that we talked about, all those possible scenarios are there. And we're here. We're in the truth. This was a journey to the truth. And the way you get to it, the way you ultimately see to it that he gets justice is following the law and the facts. So that's where we're going to start. Rules for deliberation. I think this is one of the ones I talked to you guys about towards the end of your instructions, and you're going to have sets of these, and you're going to get to read them, go over them as much as you want, spend as much time as you want. I'm going to pull a couple out. You must follow the laws that set out in these instructions. If you fail to follow the law, your verdict would be a miscarriage of justice. There's no reason for failing to follow the law. All of us are depending upon you to make a wise and legal decision. That's the law. The law is follow the law. Follow the rules. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. I want to be clear about this. Hear me very clearly. There was emotion displayed by grown men in this courtroom. Do not allow that to affect your view of the facts, because that's not right. It's not about how somebody felt, unless it's an element of the crime. It's not about somebody's emotions. It's about the facts. But you see, that's what makes the job easy for you, is that you're supposed to set aside your emotions. So I want it to be clear that if anything in here happened that's affected you emotionally, you must set that aside, because that's how the system works. And finally, I want you to remember this. Now, this actually came out when the judge just instructed you, and it came out in openings. What the lawyers say is not evidence. I have not spoken one word of fact to you during the course of this trial, because I'm not a witness, and I don't know. But I can tell you what the witnesses said and what the evidence shows. So, I'm going to go through the charges with you. I'm going to start with the fleeing and eluding, and I'm going to work my way up. Remember when we were in jury selection, I talked to you, there's a way we prove cases, and they're called elements, and each of them is like, I think I used some ridiculous analogy about like a milk stool or something, and each has the three legs have to be established to support the charge. Excuse me. So fleeing and eluding, the first one is the defendant was operating a vehicle on the street. There's no question, right? You talk about reasonable doubt. You got no doubt. The defendant knowingly had been directed to stop by a duly authorized law enforcement officer, and he willfully fled in the vehicle in attempt to elude. Now I want to make something clear here, because we've really got two different episodes, and I want you to understand what aspect of the crime this relates to. And if we go back to State's Exhibit 8, which is our pushpin diagram, what I'm talking about when I talk to you about fleeing and eluding is everything that happens from the point he leaves the scene of the murder. So all these red lines are physical manifestations of what happened during the course of that chase, because it's during that chase that lights and sirens were activated, right? Because Gary didn't have his siren on. He just had his lights on. But guess what? As you're going to hear in the instructions, that's also a crime. So, for instance, if you think about it like this, if a cop's standing on the side of the road directing traffic, and somebody comes speeding by and he says, "Hold, pull over there," and the guy goes, "No way," and flees, that is fleeing and eluding. That's a crime. He's not even in a car. Gary's in a car and had his lights on. So when he's chasing the defendant after his traffic stop, he's also chasing because he's committed a crime. And you're going to get the instructions on that in a minute, because it's a lesser included of this. But for purposes of your verdict, this charge relates to this portion of the chase. This is Sarvis. This is Briglia. This is Stubley. This is all the folks that came from all corners of the earth to pursue the man who had just murdered in cold blood a sworn law enforcement officer. Possession by a convicted felon. The judge read you a stipulation. He is a convicted felon. Okay? Also, after the conviction, he knowingly owned, used, or possessed. We know from his girlfriend that this gun he had for at least, I don't know what she said, a week and a half or 2 weeks, or at least she had seen it the first time a week and a half or 2 weeks prior to the murder. He was in possession of this. Not only was he in possession of it in the car, obviously he was in possession of it during the course of the murder of Gary Morales. And what do we got? You know, because here's the deal. I want to make it as easy as I can. We want to give you as much evidence as we can gather. What's recovered from this gun that allows us to know he possessed it? His DNA. One in a bazillion, I don't know what the number is. One in some ridiculous number on a planet that has 7 billion human beings. He possessed the gun. And then there's the aggravated assault on Clarence Bennett. Let's look at the elements. There are 7 elements to this offense. And it is that he intentionally and unlawfully threatened by either word or act. And of course, in this case, the allegation and the proof is it was by act. You can't point a gun at another human being. Regardless of whether you discharge it, the mere act of pointing it at another human being is a violation of this statute. It has to be intentionally and unlawfully. At the time he appeared to have the ability to carry out the threat. Let's go back. What do we know? We know that moments before he's pointing that gun at Clarence Bennett saw him standing in the open door of a law enforcement vehicle. I forget the terminology Deputy Bennett used, but it was unreal, shooting into it. He had the ability to carry out the threat. Even if that gun wasn't loaded, which we now all know it was after the shooting, he still had the ability. The act of the defendant created in the mind of Clarence Bennett a well-founded fear that violence was about to take place. He told you. He said, as that defendant came back from around the car and had that gun down the road, I thought I was next. And is it well-founded? Is it well-founded in the light of the fact that he saw that guy, that man standing in the open door of a sheriff's deputy's vehicle shooting? It's unreal. It was made with a deadly weapon. There's no question about that. Clarence Bennett was a law enforcement officer. There's no question about that. And he knew he was a law enforcement officer. There's no question. He'd come rolling on the scene in a cop car with lights and sirens running. So what's the evidence? Let's take a look at the evidence. And how we do that, at the time, Clarence was engaged in the lawful performance of his duties. At that point in time, Clarence was trying to basically defend Sheriff Morales and either kill or take into custody the person who murdered him. So, the judge will talk to you about weighing evidence. This is a thing we spent a little bit of time about. There are a lot of things that you can take into consideration. One of the things is how the witness acted as well as what the witness said. All of these things are factors that you can utilize in assessing the credibility of a witness. Now listen to me. People make mistakes. We talked about this in jury selection. Because somebody was wrong about a fact doesn't mean they're lying. I'm not saying to you Bertha Husky, for instance, was lying. But she's totally wrong. She totally got the facts wrong. All right? That happens. That's human nature. One of the things the judge is going to tell you, like I talked to you in jury selection, is use your common sense. Your common sense is the absolute best tool you have at your disposal as a juror. Right? Your common sense brings to bear all of your life experiences to identify a reasonable doubt from an unreasonable doubt. And, of course, assess credibility. One of the things the judge will say is, did the witness seem to have an opportunity to see and know the things about which they testified? Let's look at this. Jerry Pilarski and Albert Krajniak. Look, what can you see? You're taught two, I guess you would call them regular Joes, salt of the earth, picking up cigarette butts and broken pieces of styrofoam cups in a lot they just got done mowing. Two ordinary men thrust into an extraordinary situation. Picking up cigarette butts and broken pieces of styrofoam cups, and moments later, witnessing the unreal. These aren't just regular guys. And I think Jerry Pilarski stood up. My name is Jerry. I'm a witness in this case. That's how he introduced himself to you guys. Let's talk about their testimony. Did they have the opportunity to see and know the things about which they testified? Ladies and gentlemen, they were right on top of the scene. But we've got to consider, you must consider the fact that they were right on top of the scene. In other words, how do you process something like this? Having no experience, never seen anything like it. Are you likely to make mistakes? Sure. But overall, the big picture, their stories are similar. Who said it? One of you guys said it during the course of jury selection. You know what would make me real suspicious? If the witnesses came in and had the exact same story. That was a good point. And these guys didn't have the exact same story. But they had the same story. What's important to remember, and again, now I'm talking about their testimony as it relates to the aggravated assault, is what happened. You'll recall, I think it was Albert who mentioned something to the fact that we stood there and we watched this, and he explained how it went down, and I think Jerry did too. And then when it was over, and this guy turns with the gun, and makes eye contact with them, their God-given instinct of survival kicks in, and they run. One runs this way, and one runs that way. Jerry runs to the bushes. What happens out there after that? Jerry really has no idea. Because listen to this. Remember this. Jerry Prolarski said to you, he didn't even know Bennett was on scene shooting. He went to the bushes. And I think Mr. Glenn got up and asked him about that a little bit afterwards. So Jerry Prolarski does not help us a great deal with the aggravated assault. But Albert sure does. What does he say? What he says is, as the defendant makes contact and he sees that they see them and he tells Jerry to run, he sees the defendant leaving Sergeant Morales' car where he had just murdered him and running with a gun like this, right? Which is how you run if you want to get the hell out of there fast, get in that car and go. But that's not how he ran. What Jerry tells you is he's running like this, with the gun down the road. Now, why would you do that? It certainly isn't an efficient way to get back to your car. It's a waste of this, whatever this is, pointing motion. Why would you do that? Unless you perceived a threat down there. Okay? That's what Jerry saw. Now, Jerry's story does not match exactly with Clarence Bennett's. That's true. But Jerry's running, and Clarence is driving straight down the road and witnessing this. He's an eyewitness. He is an eyewitness. A law enforcement officer eyewitness to a law enforcement officer's murder. So, did he have the ability to see and know the things about which he testified? He describes the defendant's purposeful efforts at acquiring him as a target. Now, I want you to think about this. Mr. Glenn, or whomever it was that did Clarence Bennett's cross-examination, discussed the emotional effect or toll it had on him. He mentioned it because Clarence had a difficult time here. And he wanted to parlay that into, did you have those same kind of emotions or feelings when you're out there on the road and this incident went down? Ipso facto, therefore your perceptions about what happened could be inaccurate or unreliable. And what Bennett said was, I didn't have time to get emotional. My training kicked in. I saw a threat. I got out of the car and I began to fire down range. And more importantly, what he's saying is this. He's saying that the defendant isn't just holding it up like this and running to his car, but that the defendant is holding it up, coming down, bouncing and trying to acquire him as a target. And at some point in time, as Bennett's shooting at him, the defendant actually falls down. He thought he hit him. That's what he's saying. Now, think about this for just a moment. He's human too. He made a mistake. 4 hours after he watched his sergeant murdered in his patrol car, he gave a statement to the investigators at the sheriff's office and screwed up about where the cars were in relationship to one another. Okay? If that fact alone causes you to discount the credibility or quality of his testimony, there's nothing I can do to change your mind about that. But let me suggest some things. How could he have gotten all of that wrong? Okay, maybe Clarence said he bobbed 3 times and he only bobbed twice. Right? Maybe he bobbed the first time before Clarence shot instead of after he shot. But could Clarence Bennett have gotten all of that wrong? All of that entire event. And if you say to yourself, it's very unreasonable, then we only have a couple other alternatives. He's lying. Clarence Bennett is lying to you. He fabricated that entire event. But then I say, why? Why would he lie about that? Why would he lie about that when he knows he is going to be the state's star eyewitness to the first-degree murder of a law enforcement officer? That is to say, he rolled up on the scene, he saw the murder happening, and he's going to come in and testify about it. So why add this aggravated assault? Doesn't make a lot of sense. But Again, credibility is for you. And I ask you this finally. Is that implausible? In light of what the defendant did, which is the cold-blooded murder of a law enforcement officer seated in the driver's seat of his car, is it so implausible that in an effort to get away, he's trying to acquire as a target a responding law enforcement officer who, incidentally, if he had a motive to run when he had a gun, he sure got a motive to run, trying to get away now that he's murdered a police officer. So, that's your job to determine whether or not that testimony is reliable. But let's look at some of the evidence. I think this is kind of important. See, one of the things I talked to you about, and some of you said I think is the most important, you said you thought was the most important, is that does the witness's testimony agree with the other testimony and other evidence in the case? Okay, well, we know there are conflicts in some of the lay witnesses' testimony. Take it for what it's worth. Does it mean they're lying or does it mean they made mistakes? But let's look at here. Does this tend to corroborate what Clarence Bennett said? Remember, the defendant's moving. He's moving. He's not standing stationary. He's moving. And Clarence is, by definition, moving. Right? Now, let's be fair. A lot of people came on scene afterwards. Cars drove up. These things are going to move around a little bit. But are they going to move around so much as indicated here? Or is this indicative of Clarence moving and trying to do what? Acquire a moving target. Anybody who's ever shot a handgun, it's real hard to hit something with those. We're not talking shotgun bird shoot. This is a one shot, one chance. Clarence shot at the defendant. See, what does this story tell you? This story tells you what happens when you're shooting at a stationary target. He had the luxury of catching his victim in the car where he couldn't escape. And look where his casings are. All around in a nice circle. How does that physical evidence help the credibility of Clarence? And then there's this. This didn't come out so good, I apologize. But first, we have this shot from I'm not suggesting any one of these. I don't have any idea. I have no way of knowing, but just for demonstrative purposes, we have a shot downrange that goes here. What we know about that is that that door is open. So assuming Clarence has any small degree of competency in firearm training, he's aiming at his target, which is him, and that shot goes there. And we have another shot, the only two we know to hit the car, that are more here to the right. So there would be a difference. And again, I don't know the exact distance, but my point being, he's aiming. He's going to be shooting at moving target. Now, let's be fair. Clarence Bennett says he threw a shot downrange as the car was leaving. It could be that shot. I don't know. And I can't say. But isn't the evidence consistent with what Clarence Bennett told you? And then it comes back to why would he make it up? And then this. Clarence Bennett, when he gave his description of what he saw the day of that shooting, and when they go back and they reconstruct, and I showed him this picture on the witness stand, what did he say? Here they get a stand-in from the sheriff's office, a detective to stand in, and this is exactly what Clarence Bennett, obviously more to the right, but what he sees in relationship to the shooter and Sergeant Morales' car shooting into the vehicle. Okay? The point here is that reconstruction is consistent with how Clarence described it. So again, he's getting the big picture. Did he screw? He said, did you hear the 911 tape? Dispatch, he said his pants were blue. He's wrong. I think they're blue, he said. He was wrong. He also said he went west on Naylor. Well, there is no west on Naylor. It's only north and south. But you know what? It was unreal. It was an unreal situation. And so he made a couple of mistakes. But this is backed up by all of the evidence and his overall credibility. So that takes us to the final charge, which is first-degree murder. I will not show you any more autopsy photos. Again, what you know, everyone knows. Sergeant Morales is dead. Sergeant Morales is dead, and his death was caused by the criminal act of the defendant, not in self-defense, not warding off an excessive use of force by an enraged law enforcement officer, or a racist law enforcement officer, or a prejudicial law enforcement officer, but by a criminal act that he committed out of his own selfish desire to avoid prison, to avoid responsibility. And the killing was premeditated. So, this is what we're all here for, right? This is what it's all about. One of the instructions you're going to get is if you find the defendant guilty, I don't think there's any dispute, question about this, that Gary Morales was a law enforcement officer on duty, engaged in his duties. So there's no question about that. That's what we charge him with, that's what we're asking you to convict him of. The judge will instruct you on this. He'll also tell you that all St. Lucie Sheriff's Office deputies are law enforcement officers. But this is without dispute. So what is killing with premeditation? Some of you thought it was something else when you came in. Some of you thought days of thinking and planning, preparing, and then execution of a plan. But that's not the law. And it really can't be the law, because it would be impossible, really, for us to prove something of that nature or to that degree. It's killing with after consciously deciding to do so. That means it's something you thought about. That decision's got to be in your mind. That is, it had to be in his mind at the time he walked up to Sergeant Gary Morales, pointed this gun, and shot him in the side of the head, in the head. The law doesn't fix the exact period of time that must pass between the formation of the intent and the premeditated intent to kill. Could it be 10 seconds? Could it be 30 seconds? Could it be 10 days or 30 days? Yes. It depends on you. It must allow enough time for reflection. What does that mean? That means I've thought about it. And I thought, if I do it. And then I do it. So it's reflecting on what I'm going to do, what's going to happen, all of which can happen in an instant. And then, of course, it must be formed before the killing, which makes sense. I don't know how you could have a premeditated killing if you killed somebody and then afterwards said, I really want to kill that guy. Doesn't make sense. Of course, it's got to be in your mind before the killing. Here it is. This is a question of fact, because this is what's in somebody's head. How can I prove to you what's in somebody's head? It's a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence at the time. So what is this instruction telling you? It's saying look at the facts. Look at the circumstances, because if you don't have anything else, you look at the circumstances, how the crime was committed, the nature of the crime, the circumstances surrounding the crime. What is this? It's a question of whose box is it? The intent with which an act is done is an operation of mind. It is therefore not always capable of direct and positive proof. It may be established by the circumstantial evidence like any other fact in a case. That's the circumstantial issue we talked about. Remember my box? Whose box was it? Some people took a little longer. Some people said it was mine right away. It's not a fact. It's not a single fact. It's not this mere fact that he stood at the open door of a law enforcement officer's vehicle and shot into it and murdered him that makes him guilty. But it's a whole bunch of facts. And at the top of the mountain, and I'm going to sit down, at the very top of the mountain is he had a motive. See, I told you when we started this process, I feel kind of a little guilty about it sometimes, telling you I can't prove anything to you beyond all doubt when the evidence is going to prove beyond all doubt. Or do I got to prove a motive when I don't have to? Do you expect me to prove a motive because I don't have to? But this motive really, the most important point of the convicted felon thing is not because you should convict him because he's a convicted felon. That would absolutely be inappropriate for you to consider it for that purpose. The most important part of that is, because of that status, he couldn't have a gun. And he took or had that gun, he either took or had it, it's supposed to be left in the car, in the car when he entered the car with a suspended license. But you see, the problem is, on a past occasion, you heard Detective Wednesday, got pulled over, and he had a suspended license, and he got arrested, and they searched his car. He didn't forget it. And he knew this day that when Gary was pulling him over, for what reason was again lost to history, that Gary's going to find he had a suspended license. What a big deal. But then he might also search the car if he arrests him. And if he does, he'll find that gun. And if he finds that gun, he's going to prison. He wouldn't let it happen. And so, to avoid the responsibility for his acts, Sergeant Rouse did nothing wrong. He just put on his badge. He, to avoid his responsibility for his actions, took human life. And so today, at the end of this, I'm going to ask you to hold him responsible. I'm going to ask you to follow the law. I'm going to ask you to follow the facts. I'm going to get one more opportunity to talk to you. Mr. Glenn's going to step up here. I ask you to give him the same attention you've given me, and I look forward to concluding this matter with you this morning.
Thank you. If you'll give Mr. Glenn your attention, please.
Just give me a moment to set up, sir.
Yes, sir.
Well, I guess you know what jury selection was all about now. You all spent a lot of time talking about a lot of different things. And now you know why. I want you to take a journey with me through the evidence so that we can talk about what's wrong. Okay? Because at the end of the day, all of you promised that you would keep an open mind and consider everything. And I'm asking that you do that. Because even though it looks neat, bundled, and concrete, it's not. As I told you in opening statement, they don't know what happened. I don't know what happened. You know what we're doing? We're guessing what happened. You have to decide what happened based on the evidence you've heard. So let's take a journey, shall we? Remember 2 times, 25 seconds and 48 seconds. How do I know that? The 911 dispatch recording. Now, of course, I couldn't hear it, so I couldn't tell you. So I got together with my co-counsel, and we played that recording probably 100 times. Something stood out to us. Let's take a journey. February 28, 2013. Law enforcement doing enhanced patrolling in the Silver Lake Estate. Gary Morales goes to work that day, as you ordinarily would. Well, guess what? Eriese Tisdale gets up that morning, as you ordinarily would. Goes to the store for his girlfriend. Jessica testified he went to the store at the 7-Eleven, or the store behind the 7-Eleven. Where is that? It was an Oleander. Presumably left the store and he's on his way home. Very careful. Watch this. Canner. Yeah. Why is that important? To driving down Canner from Oleander, you make a left onto Canner, right? You're driving down Canner, and you make a right on the Muir. They're important. What did Casey Federer tell you? Gary Morales made a left on the Muir. Law enforcement doing enhanced patrolling in the Silver Lake Estate. If we believe the dispatch is accurate, and I submit you should, you know why? Because it can't be messed with. It was recorded in real time. It can't be interpreted. It can't be affected by emotion, bias, or sympathy. It is what it is. What happened on that dispatch recording? We're going to come back to that. Mr. Tisdale going down Muir. Gary Morales is right behind them. They're going at a high rate of speed. Miss Federnick is here. Eriese lives here. What happens next? Turns. Gary Morales turns and stops. How do we know he stopped? 25 seconds, ladies and gentlemen. We're going to come back to that. Gary Morales sat there for 25 seconds. What happened next? I have theories. I don't know. But I would submit to you that he sat there for 25 seconds and he got out of his patrol car and he approached us. Think about this. Do you believe after chasing us down the street that Gary Morales would just sit in the patrol car and wait? You decide. I'm not going to tell you what I think because you know what I think. You decide. Is that logical? He's pursuing this red car. There's an enhanced patrol going on, and he's just going to sit there for 25 seconds and not get out of his car. Baloney. He got out of his car. But something happened, and we don't know what. But we know there was the first traffic stop. Stay trying to tell you there wasn't. That's baloney. There was a traffic stop. No officer is going to sit after chasing a car and not get out. We know this wasn't a felony traffic stop because Gary Morales didn't follow the procedure for a felony traffic stop. What happened next? It takes off. Gary Morales takes off. Dirt road, paved road, dirt road. Very important. Eric takes off, Gary Morales follows him. Michelle I, what did she tell you? I'm sorry, Michelle I, what did she tell you? Well, I'm outside, I'm working on the door. I see this little red car coming. A few moments later, I saw the sheriff's car. What's important is not what the witness to tell you, but it's what the witness to tell you. Gary Morales is driving a police enforced Crown Victoria, big V8. Those things are fast. They have to be. Tisdale driving a Toyota Corolla. Now, common sense, ladies and gentlemen. One's obviously a lot faster than the other. We're going to talk about it more later. Let's continue with the story. Takes off. Gary Morales takes off. We know Gary Morales caught up to him quickly. Why? We saw that a few moments later, I see a sheriff's car. But if there hadn't been a traffic stop, that sheriff's car would have been on the bumper of a red car the whole time, because he's got ample power to do it. So, makes the right-hand turn on the nail and almost wipes out. Remember that? Almost lost control, slamming the stop sign over here. Which tells us what? He's going back. Gary Morales chased up nail. You know what happened to you. 48 seconds. How do we know I'm right? Because it's on the dispatch recorder. Listen to it, time it, use a stopwatch. We did. What happened? There was a traffic stop. Morales, we called out, King Orange and Muir come to a stop for 25 seconds. Then the next thing you hear, that's all, he's taking off on me. Start the clock. North O'Neill. Deputy Bennett shots fired. Stop the clock. 48 seconds. This whole thing took 48 seconds. I told you this is about a sudden spontaneous act. From a takeoff, actually not from a takeoff, from the time I reached up and called it in. To the time Bennett called it in, 48 seconds. "25 seconds and 48 seconds. That's how fast this happened. Obviously, we know at some point Mr. Tisdale gets back in the car and drives off, and there's a chase that takes place that he eventually stopped. This was a sudden and spontaneous act. How do we know? 48 seconds and a lot of travel. We don't know why these events happen. We don't. But I want to argue to you and stress to you that the biggest issue in this case is premeditation. That's the state's whole case. This is their theory of the case. Mr. Backett just said it. Eriese Tisdale had been arrested before. His car had been searched. He was afraid that was going to happen again, and this time Mr. Morales was going to find a gun in the car. He was going to be arrested for a gun and go to prison. Now, let's think about that for a minute. Does that make sense? Does it make sense? I have a gun in my car. I'm driving around like a maniac. I'm thinking about going to prison, so I'm going to get out and shoot somebody and hope I don't go to prison. What's wrong with that argument? There's an enhanced enforcement going on in Silver Lake Station. This place is crawling with cops. Listen not only to what the witnesses tell you, but what the witnesses tell you. You think Gary Morales was the first law enforcement officer to saw him that day? These guys are everywhere. So, why would he do that? Why kill a cop over a gun? Sure, you can go to prison for it, but why? You could die for this. Prosecution can't prove But this is the best they can come up with. Because guess what? If you don't believe this, you don't have premeditation. That is why we have this theory. Let's talk a little bit more about us. What's in the picture? Very important picture, ladies and gentlemen. What's in it? Inside of a Toyota Corolla, check. Picture of a gun, check. Not what I'm talking about. What else? Look at the transmission lever. It's a stick shift. Now, I drive a stick shift. How do you drive a stick shift? You have 3 pedals. You have one hand on the lever and one hand on the steering wheel. Extremely important fact. Listen to what the witnesses tell you, but listen to what the witnesses tell you. Jessica Maldonado described driving a stick shift. You go to take off. You push the clutch in, you shift in the first. You let the clutch out and you slowly go into the gas. You reach speed, push the clutch in, shift in the second. You repeat the motion. You reach speed, you shift in the third. You repeat the motion until you get up to top gear. Reverse, you come to a stop, and you either all the way over to the left and up, or all the way over to the right and back. That's a stick shift. What's so important about it? It requires 2 hands. This isn't your average minivan sedan. You put it in drive and just roll down the street. It takes some thought, hand-to-eye coordination, and concentration. Very important when we're talking about premeditation. Very important. So let's go back to 48 seconds. Eric is rolling down the street. Morales is right behind him. What do we know? Well, depends on who you believe. We've got inconsistent testimony here. We know one thing. Eventually they both come to a stop. That much we know. We don't know if Eric spun around, as both the Husky says, or if he stayed straight. We don't know if they both came to a stop at the same time, or if Eric came to a stop first and then backed up. We've got inconsistencies all over the place. But imagine this. Eric is in front. He's been pulled over before. Why? Because you heard an evidence. He's been arrested before. Why? You heard an evidence. His car's been searched before. Why? Because you heard an evidence. Now think about what's happening on February 28th of 13. Gary Morales is pursuing him. Lights, no siren. Check. I don't care if Palestinian procedure says it's allowed. It actually doesn't, but if it says it's allowed, fine. Eric is suspected. Is he being chased by a law enforcement officer with no siren? Who turned onto the street after him? He comes to a stop. Something happened, and then the chase continued. And continued on there. Still no siren. Then we know at some point Morales comes alongside of us. Gets further up, and then in front of us. So now he sees this patrol car in front of him, blocking him in. He doesn't know what's going on. He gets out of the car. He runs over to Morales' car and he fires. Now, this had to have happened fast. Why do we know? Because the 48 seconds include the time it took them to get from here to here and fire. This thing went so fast, no one knows what happened. Even the guys that were there can't get it right because it's happening so quick. 48 seconds. And then he's gone. Eric is gone. That is your timeline, ladies and gentlemen, the 911 reporter. You know why? Because it can't lie. It can't change the story. It can't get confused. It can't be affected by emotion. It is what it is. We know this happened fast. This is the state attorney's argument. Eric is driving his stick shift car. He's accelerated. Remember? Katie Federer, Albert Kraniak, Jerry Polarsky, Michelle I. Everyone said they're going fast. Well, what happens with the stick shift car if you're going fast? You're shifting through the gears. You can't go 80 in first gear. What happened? Eric is shifting. Putting pressure on the gas, car shifting, shifting. Pressure on the gas, car shifting, shifting. Turning. Prosecution wants you to believe that this is premeditated in light of those facts. Now, I know what they're going to get up here and tell you when I sit down. They're going to talk about big gun. They're going to talk about the glove box. They've got the whole plan set up. This is what it is. Jessica Maldonado, we called her in here, testified that she had seen a gun and else had a gun. And that one time, maybe two, she had seen the gun in the glove box and the magazine with a bullet holder next to it. You know, they called Jessica for a reason. This is it. A week or two prior, that did not tell us anything. Then magically, on that day, Eric had the gun in the glove box, the magazine holder next to it. He mowed in on home from the store behind the 7-Eleven. He decided, I'm going to kill the deputy because I don't want to go to jail or prison. And he reaches in the glove box, gets the gun out, takes it out of the holster, reaches in the glove box, gets the magazine holder, the bullet holder magazine out. He puts it all together. He racks the slide and he gets it ready, all while he's wiping out on the nailer and running from Sergeant Morales. All that within 48 seconds. That's the argument. Is that realistic? Is it? We talked about guns during jury selection. People who carry guns for self-defense or protection, you know who you are. What good is an unloaded gun if you're faced with a threat? You know how long it takes to put that crap together, right? Come on. That gun wasn't unloaded. It couldn't have been. This is how fast this happened. Driving a stick shift car at high speed on a dirt road and almost wiping out. You notice all these clues I dropped to you guys during opening and during jury selection? Well, here it is. It's not just what the witness did tell you, but it's what the witness did tell you. "25 seconds and 48 seconds. Don't believe me. Time it. Play it. Live with it. Let's talk about Albert Kraniak and Joey Polarsky. I admit to you, these men are the most impartial witnesses in there. Mr. Polarsky from Michigan, Mr. Craniac from Middleburg, Florida, which is up near Jacksonville, St. Augustine. These guys are just out cleaning the yards. They've got no stake in this. They saw what they saw or what they think they saw. So let's talk about that. Mr. Pulaski comes in and testifies first. He's a little odd. But what did he tell you? He essentially said, I'm there, we're on the side of the road, we're cleaning up a cigarette butts, whatever. First thing he said is, I noticed the sound of a car. Then the car go by him. Red car come to a stop, police car come to a stop along him, and starts to come over in front of the red car. What Mr. Pulaski really zeroed in on is, door of the red car open, door of the police car open, guy from the red car come down with gun in hand. That's an important fact. Why? Because it's ready to go. And what does he say? He runs over to the police car and starts shooting. He said it's just kept shooting as if Eric was on autopilot. But Eric is accused of premeditation, yet he's acting in a way that is almost automatic. But the prosecution is going to argue that he had time to stop and think and plan this out before he did it, that he reflected on it. Then 25 seconds and 48 seconds, all while driving this car and putting the gun together. This doesn't make sense. Not just what the witnesses tell you, but what the witnesses tell you. Finishes shooting and then runs back to the red Toyota, gets in and takes off. Mr. Craniac comes in and pretty much says the same thing, doesn't he? No, the stories are not identical. One very good way that they differ is that Mr. Pulaski says the gun could have been up when he was running back to the car, it could have been down. He's not sure. Mr. Craniac said, I'm sure it was up. Of course, the prosecution wants it to be that way because that's their argument that he was pointing at Clarence Bennett. Now let's think about this. I'm going to come back to that later. Think about this. You know, I accept that this is probably a very difficult event for many people in this courtroom. Their friends, family member, loved one is dead. Believe me, I get that, I do. I wouldn't know how I would feel if it were my friend or family member or loved one. So I understand that. But as Mr. Backadar said to you, you can't consider that. Just like you're not supposed to look at Eric and feel bad for him and let him go. That's not the law. They're not asking you to do that. We're asking you to make a decision based on facts and reasonable inferences from those facts. In other words, we are asking you to find the truth. This is the thirst for the truth. It's just their version different from mine. Because at the end of the day, you decide what the truth is. We just tell you what we think the truth might be. So, with that, let's talk about Deputy Bennett. Look, he was upset. He was emotional. But he did give us some details. Most important detail he gave us, and this was important, I want you to think back to the testimony about the gun, or the reconstruction, or the crime scene, and what did they say? This particular gun holds 10 in the magazine, right? 7 shell casings were recovered at the scene, right? Keep the knot on here, if you guys remember the important fact. It's not just what the witnesses tell you, but it's what the witnesses tell you. Why? Because 3 were removed out of the gun after this is over. Law enforcement carry their guns in a ready-to-go fashion, maximum loaded. I assume, based on the way it's been described, they fill up the magazine, they put it in the gun, they rack it, slide, they drop the mag out, they put one more round on, put it back in, we're ready to go. Well, this gun couldn't have been that way, there would have been 11 shots. Now, the prosecution is going to try to argue that the fact that there weren't 11 shots meant it was disassembled. Come on, look at us. He's not a cop. He doesn't know about this maximum efficiency loading of a gun. Convict the cop. There were 10 shots in that gun, and all 10 shell cases are outside or out the door. Why is that important? Because of Deputy Bennett. Deputy Bennett said, I'm coming down the road. I see shooting into Morales' car. But when I cross-examined him, I said, before you made the turn on the nail, you heard 5 gunshots. He goes, no, maybe 3 or 4. All right, whatever. 3, 4, 5, 7. The shooting started before you turned on the nail. Why is that important? 48 seconds. Doesn't include Deputy Bennett. His time frame is even less. So Deputy Bennett turned on the nail. By his own admission, 3 or 4 shots, boom, 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 are gone before he makes that corner. Shootings up here. He said, I saw her shooting repeatedly into Morales' car. What's wrong with that? He's too far away. Remember, Lucie and I said, he's firing away, autopilot. 7 shots, boom, 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 we're done. Deputy Bennett on a mission, 3 to 4 shots he heard before he made that corner. I impeached him on it. You're trained law enforcement. You know gunshots when you hear it, yes. Well, it's either one or the other. You either heard 3 or 4 shots here, you would further up nail when it happened. But that's not what he said. You got to decide what you believe. You believe Lucie and guy, or you believe the deputy? Who's best friend with Gary Morales? Who was his boss? Co-worker? I'm not picking on that. I'm just asking you to look at the facts. You have someone here who is emotionally invested in this case, and someone who is not. Who's more credible? I would argue to you, Lucie and Craniac are more credible. These 2 dudes don't even live here. They've got no stake in this. None. This entire investigation was done by the St. Lucie County Sheriff's Office, and all of them are co-workers with Gary Morales. Now, Deputy Bennett says, I'm driving down the road, I see this happening in front of me. I'm perceiving it, I can't even believe it, it's unreal. Okay? He said he stopped his car, he gets out, and he engages us. And he says, Us doesn't run back to his red Toyota. He says, he's squaring off with me. He's ducking, trying to avoid my shots. He's trying to take me out, line me up in his sight. Really? In less than 48 seconds? Really? You believe that? I don't know what happened out there. They don't know what happened out there. But the dispatch recorded is your friend. You just live it, embrace it. Timing, whatever you have to do. Deputy Bennett's a 9-year veteran of the Tennessee County Sheriff's Office. You're a training officer, remember? You talked about how he stopped out with another deputy to make sure he was okay, because he was new to the force, but he didn't have to stay with him, because that deputy also had prior experience. Okay. We have a 9-year veteran. You're a training officer, which means they trust him to train others. Not just what the witness will tell you, but it's what the witness will tell you. Prosecution wants you to believe, and Deputy Bennett wants you to believe, that he squared off with us. Squared off with us in that small distance. You saw how narrow the streets are in the photograph, right? 2 police cars barely fit in the street. Look at how small that street is. They want you to believe that Deputy Bennett, 9 years experience, still training officer, squared off with their double shot and not buying it. Why? He was accurate enough to get the edge of his car door. This man knows how to shoot. I'm sure the prosecution's going to get up here and say this was a lucky shot. But he didn't just get the car door. He also got the back bumper. Based on the state on it. This man is a good shot. So what do we have? If we believe that Deputy Bennett is a good shot, and he knows what he's doing because he's a 9-year veteran, and he's a field training officer, then, well, what do we have? We have a major conflict in the evidence of what we have. The judge is going to tell you a reasonable doubt can arise from the evidence, the lack of evidence, or conflict in the evidence. Do you believe that Deputy Bennett squared off, fired, I believe, 5 rounds in the direction of this man and missed each one? Do you believe that? But yet, hit the bumper and hit the door. My argument is that's illogical. I don't know what happened. They don't know what happened. I have a theory. For what it's worth, hear me out. I'm not saying it's the truth, but I don't know what happened. This is my theory. Deputy Bennett's coming up now. He can't believe what's going on. And he sees us running back to the red Toyota. And he sees his buddy's car with the door open and not moving. he knows something bad happened. And he sees a gun in the other's hand. He stops, he gets out, and he starts firing at the other, getting ready to leave. Eric is getting in the car, just boom, got the door, but didn't get him. Why is that reasonable? Because Lucie and Connie got both said shots were being fired and others were taken off down there. But we all know Bennett only got out about 5 shots. So, it's either one or the other. At least 2 of those shots hit Eric's car. Also think about Deputy Bennett's inconsistency. I wasn't trying to pick on him when I impeached him with those inconsistencies, but that's important. I'm not trying to pick on anybody when I bring up something. It's about a story for the truth. 4 hours after the shooting, Deputy Bennett told his superiors the red car was on the left. In front of you, he said the red car was on the right. That's a big deal. I understand he's human, as the prosecutor pointed out, but that's a big deal. Because 4 hours after the shooting, his recollection should have been the best. Not 2.5 years later. Almost 3 years later. Now, Lucie and Connie, I tell you, the red car was on the right. So you have a situation where 2 witnesses kind of outweigh the one in that statement. Fine. Based on the shooting and based on the position of Morales' car, we know the red car was on the right. But here's the thing. You got a man who told his superiors who were investigating a law enforcement officer's shooting. He just charged his gun. He had to be investigated. That the red car was on the other side of the road. Not good. Not good at all. It doesn't stop there. Bennett also says, I came down the street, I saw Earl shooting, I saw him run over to his red car, and that's where I engaged him, at the side of his red car. 4 hours after the shooting, on February 28th, 2013, at 1:55 p.m. in the afternoon, he says, no, Eric was over by Morales' car when I shot at him. Now we got 2 big misconceptions or inconsistencies or whatever you want to call it. That's a big deal too. Why? The physical evidence doesn't line up with him being over by Morales. If you believe where those shell casings landed. So why did he tell his superiors that's what happened? I don't know. I can give you a few theories, but I can tell you this. You better be darn suspect about what he told you. They charged us with first-degree premeditated law enforcement of a law enforcement officer and aggravated assault on a law enforcement officer. Why is that important? Doesn't the aggravated assault make the murder thing so much worse? Isn't it so much more egregious? Isn't it possible you'll be less likely to find premeditation if you don't believe the aggravated assault happened? Doesn't that make it more possible that it might have been a sudden and spontaneous act? Imagine that. It might not have been premeditated. Imagine that. This is a man, my client, is a man whom prosecutors are arguing to you had great tactics, that he could overcome a deputy. Great tactics. Let's just stop there. If he's got great tactics, and he's trying so hard to kill a law enforcement officer, then why didn't he shoot at Bennett? One's dead. Doesn't matter at this point, right? Why not shoot at the other one? Oh, right, he didn't shoot at the other one. Evidence indicates he didn't even point at the other one. But they don't want you to believe that because that makes it less egregious and less bad and less likely you'll find premeditated motive. The worse they can make us seem, the more likely you ought to go through with that's their motto. And we know Ellis didn't shoot at Bennett. You know why? 7 by Morales, 3 found in the gun, total 10. Unless you think by some miracle, Ellis had an unloaded gun in his glove box. He's driving that 6-speed manual transmission car at high speed on asphalt and dirt roads, dealing with the transition from one to the other, steering, controlling the car, reaches over, opens the glove box, gets the gun out of it, gets the magazine out of it, loads the gun, whacks the slide, drops the magazine, gets another chance, another bullet, puts it in, puts it back in. Come on, we know that didn't happen. There were no loose bullets found in the car anywhere. We know that did not happen. Could not have happened. It's not just what the witnesses tell you, it's what the witnesses tell you. The search for the truth requires not only listening to what you're told, but critically analyzing what you were told. Briefly, I want to talk about Morales being shot and the order of the shot. It's important that you remember no one could tell you what order it happened. The prosecutor insinuated that the bullet strike to the side of the car happened first, and then the shot into Morales happened after that. We don't know that for sure. There is no scientific way to tell you that. Pulaski thinks that's the way it happened. He's not sure either. He's on the other side of the car. And for what it's worth, it doesn't really matter. The defense was brutally honest with you from day one. He told you, shot Gary Morales. And as a result of the shooting, Gary Morales died. It isn't about that. We gave you that from day one. This is about premeditation with the lack of it. The lack of it. Let's move away from the shooting a little bit. A couple of things we need to talk about. Several deputies testified that the shooting pretty much went all over the Silver Lake Estate neighborhood. But there are two things that I think we need to discuss. One, Deputy Stubley talked about how he pursued the red Toyota, remember? He talked about how they made their way down Glenview on the US 1, and then there was that big U-turn in US 1, and then it goes back down Glenview. And Stubley says, this is important. He told you he got out of his car, took out his gun, was going to maybe shoot at us, but didn't. No fault. I'm not faulting him for that. Just listening to my point. He's standing outside of his car. He's in a very good position to steer us, right? Eric goes back down Grimsby and then turns this way. This is where Deputy Starvis picks him up. Why is that important? Deputy Starvis tells you he thought he saw Eric laughing. They're important. Why is that? Stubby didn't see him laughing. What's humorous between here and here? Nothing. Why does all of a sudden not laughing and then laughing? It's not just what the witnesses tell you, but it's what the witnesses tell you. Because if Eric is laughing, that makes him more egregious. That makes him bad. That makes him a bad convicted felon. That's what they want you to believe. So I would submit to you, who do you believe? The man who's standing outside of his car, aiming him up? To take a shot? Remember, aiming him up, to take a shot. Lining him up, trying to make sure he gets them. Or the man who's driving down the street and says, oh, I saw him make the turn. He was laughing like, this is the game. Then that got objected to, but that's what it did. Oh, judge totally disregard that, but he did say that. I wonder why. Is there an agenda there, maybe? And make this guy look as bad as we can? Gary Morales is my colleague, my friend. You need to take into account the relationship of the witness. That's very important. We're all subject to bias. All of them. Me, them, everybody. And if you don't believe that, you're kidding yourself. I've got bias. The defense team has bias. Prosecution has bias. We all have it. We're all human. I don't know how I would have reacted if my friend had been shot. Probably shouldn't, but I would have done. But the reality is, you need to question that testimony. If you don't believe that laughing, then Eric is not bad. Eric is not egregious. Maybe he's just a normal guy that made a bad mistake. Maybe they didn't premeditate it. Maybe this is going to be a tough case for you guys to figure out. But this is our thirst for the truth. And all of you, all to the conclusion, promised us that you would do that. And that's why you're here. Figure out what is the truth. Another thing about Deputy Stubbs' testimony is that eventually he ended up at the point where Eric's car stopped. And what does he tell us? He tells us Eric got out of the car, said, please don't kill me. That's very important. This man was laughing because he was running law enforcement all over the neighborhood and this thing was a big joke. Why would he say, please don't kill me? Why? Maybe because he's in fear of his life. Of course, I'm sure the prosecution is going to tell you because he knows what he did and he has consciousness of guilt. Or maybe it's that too. But maybe this man, Eric, was in fear of his life the whole time. Now notice, I'm not arguing to you he acted in self-defense. I'm just saying maybe he was in fear of his life. Ladies and gentlemen, we spent a lot of time talking about different things during jury selection. And one of the things we talked about is fight or flight. One of the things we talked about is reacting and overreacting to the situation and how two different people can overreact to one another and create an explosive situation. That's exactly what happened today. This should not have happened. both of these men should have gone home that day. But it did happen. We can't change history, but it's up to you to figure out what the heck happened and what it is really guilty of. Let me go back to the beginning of the case. Remember the judge read you the policies and procedures. That's important. Because in reading them to you, I'm sure you noticed that some things were not done. Namely, description of a person in the car, number of occupants in the car, and the reason for the stop. Why? I don't know. They don't know. We don't know. Listen to the dispatch report. I want to talk to you in particular about aggravated assault on a law enforcement officer. This is the count that involved Deputy Bennett. What must the state prove? Tisdale intentionally and unlawfully threatened, either by word or act, to do violence to Deputy Bennett. Let's stop. If you assume, for the sake of argument, that Eric ran back to the red Toyota with his arm outstretched, is that an intentional act to do violence to Deputy Bennett? Remember, while running, prosecutors already argued it is. I submit to you it's not. And then, of course, all the things we talked about that's wrong with that testimony that that even happened. I would ask you to consider this. Pulaski and Kraniak both agree on one thing. They never saw that. How do these two men see everything but that and it actually happened? How? This whole deal took less than 48 seconds. How do these two men miss the shootout between Bennett and us? They see everything else. Now, you're probably thinking, well, they both split. One went this way, one went this way, one went over the bush. Okay. But what did Pulaski tell you? I'm former military, I'm going over the bush, but I'm still looking sideways. I want to make sure this guy's not coming after me. Which means what? He never took a dive off of us. Kraniak, same thing. They're watching even though they're running away. You truly believe that us squared off with Bennett and these two men, both of them missed him. They didn't even know that Bennett was there until Eric was in the car, taking off, and then they noticed he's being shot at. Gee, maybe that's because that's what happened. Physical evidence sure points to that conclusion. You decide. Let's also talk about premeditation for a minute, and first degree murder, second degree murder, manslaughter. It's true, the law does not fix an exact period of time to determine reflection. That's true. But guess what? There has to be reflection and there has to be evidence of it. This is why the prosecution spent so much time talking about circumstantial evidence during jury selection. Because you know what? They can't prove what was going on in Erice's mind. They have no evidence of premeditation. They have a theory. Like I have theory. they have no evidence. Remember, what the lawyers say isn't evidence. They have a theory of premeditation, but they have no evidence of it. Yet they want you to cross that huge bridge and find it with the premeditated murder based on the theory that Eric was a convicted felon, that he had a gun in the car, that he had been stopped before, his car searched, and he was afraid that that was going to happen this time, and he was going to go to jail or prison. Well, the problem with that argument is they're essentially telling you in an area where we have enhanced enforcement, law enforcement everywhere, you really believe Eric didn't see some of those traffic stops on his way home? Do you? How many law enforcement came in here and told you they want a traffic stop when this came out of the radio? Or they were leaving this area, leaving that area? Can't have it both ways. Either one or the other. Enhanced enforcement. And Eric goes, I might kill this cop. I might get away with it because I don't want to go to jail as this dog. That is ridiculous. It is. It really is ridiculous. I'm going to murder this man so that I don't go to jail over a gun. And I think I'm going to get away with it. And I'm going to get out of the area. He thought Abbott and Jerry Washington. You see how asinine this is? There are two witnesses right there watching him. They look at the black man with the dreadlock, the white shirt and the camouflage shorts. Oh, I'm going to kill this guy and I won't get caught. Come on. Really? Really? That is the dumbest thing. Now, if that was a true argument, he'd have picked off those two dudes too. But he didn't even point at them. It just wasn't about them. It wasn't about killing anybody. It was about fear. Irrational fear, but fear. They don't want you to believe that because then they don't have premeditation. The reasonable doubts can arise from the evidence, a lot of evidence, confidence in the evidence. And in this case, you have nothing but conflict and lack of evidence. Eric is not guilty of premeditation murder. Cannot be, because there's no evidence of it. And the theory that they're offering you stinks. Just plain stinks. Aggravated assault stinks. Just plain stinks. There's more wrong with it than is right. It's not just what the witnesses tell you. It's what the witnesses tell you. I promise you this was going to be a hard case. And I'm sorry for you that you're in the middle of it. But you promised me, and you promised the prosecution that you would help us search for the truth. Please do that. Please do that.
Thank you. Folks, we'll take just about a 5-minute recess before we hear the state's summation. Please don't discuss the case among yourselves while I don't discuss it in your presence. We'll have you back very shortly to conclude. Okay? Watch your steps up and down. Jury's been excused. We'll just go off the record for a minute. Mr. Bagadal, do what you need to do, and when you're ready, let us know. Okay.